All rise. You may be seated. All right, Mr. Foreperson, has the jury reached a verdict?
Yes, we have, Your Honor.
Sir, I would ask you to hand that folded document to our bailiff. He will deliver it to our clerk. And I will direct our clerk to read the verdict aloud. I would ask the defendant to please stand and face the jury as the verdict is read. After the reading of the verdict, I will say all of you to ask for your affirmative response. If you do not have an affirmative response, indicate so as well.
In the Circuit Court for Morgan County, West Virginia, the State of West Virginia versus Andrew J. McCauley, Jr., case number 25F35. We, the members of the pettit jury, as to the issues joined, find the defendant, Andrew J. McCauley, Jr., as follows. Count 1, murder. Guilty of murder in the first degree. As to count 2, death of a child by a custodian by child abuse. Guilty. As to count 3, concealment of a deceased human body. Guilty. Signed today's date by the foreperson.
Is there a request that the jury be polled?
So requested.
So, Madam Clerk, if you would read the names of the juror numbers, and when you hear your juror number read, if you would give an affirmative or negative answer. An affirmative answer is that is in fact your true verdict.
Juror number 220.
I did.
Number 4. 47. 246.
Yielded.
23. 310.
Guilty.
324. 290.
Affirmative.
60. 342. 275.
Guilty.
And 282.
Each of the jurors has been polled and has answered in the affirmative that the verdict of the jury, as read by the clerk, was then and is now their own true verdict. Madam Clerk, if you would counsel can be seated. If you would hand that verdict form to our bailiff, if the bailiff would show it to counsel, and I would ask whether or not there are any objections as to form.
No objections from the state, Your Honor.
Not asking for them.
Then I will direct the clerk to record the verdict form. All right. So at this point in time, this is the proceeding where we will now address the issue of mercy. I'm assuming, counsel, do you want to take up anything off the record before we proceed directly into the mercy phase?
Nothing from the state.
Other than the issue that the court raised.
Sure.
Nothing else from the defense.
All right. So at this point in time, ladies and gentlemen of the jury, you have reached a verdict of murder in the first degree. A murder in the first degree is without mercy. If no mercy is attached, requires me to sentence the defendant to prison without being eligible for parole. A finding that mercy attaches to the verdict, or a finding of mercy, means that they will be eligible for parole in 15 years. However, there's no guarantee that they'll get paroled in 15 years. So if after 15 years of actual time served at some date on or after 15 years, they may, at the wisdom of the Board of Parole, be released into the community. The other hard edge around that mercy determination is it's like a verdict of guilty must be a unanimous verdict. In other words, you must all agree that mercy attaches or not. There is no burden of proof associated with this. You get to simply hear each side's position regarding the issue of mercy. So, because there is no burden of proof, this is more like a sentencing phase of the trial that the jury is involved in. Typically, we would allow the defense to go first if the defense chooses to go first. Do you wish to call any witnesses, Mr. Arnold?
May it please the court, Mr. James, Mrs. Moore, ladies and gentlemen. This is a reset where we are right now, because now you're tasked with an entirely new matter, an entirely new question. In West Virginia, judges hand down sentences in criminal cases, in all criminal cases with one exception, and this is that exception. Our legislature decided that in these cases where the sentence is life with mercy or without mercy. That distinction, as the judge mentioned, is whether after a decade and a half of incarceration, an inmate might be eligible for parole. That is, whether or not after a decade and a half, the parole board would ever have the authority to consider an inmate's application for parole. And you're the ones to either convey that authority or to withhold it. I want you to understand something very important in this analysis. The authority the parole board might have to consider an application for granting parole is not the granting of parole. Parole board members are appointed by the governor. There are 9 of them. They have no real limits on what they may consider. But the very first question a parole board will consider in reviewing an applicant for parole is community safety. That is first and foremost. It's right in their mission statement. It does not allow for lawyers to appear and advocate. It does, however, solicit and ask for input from victims' family members prior to making a decision on parole. It also asks for opinions from the prosecuting attorney's offices. It will also review the facts underlying the offense. And it may deny parole for no reason, and its decisions are not reviewable. So I want you to be clear that an attachment of the word mercy is not an award of parole, not by any means. In asking you to attach mercy to this verdict, we do not ask you to award parole after 15 years, 18 years, 21 years. The parole board will consider somebody facing a life sentence after 15, but if they do not grant parole, they will only reconsider in 3-year increments. We do not, in fact, ask you to award parole at all. What we ask is that you leave that really important question to a distant future, to another body, the parole board, whose obligation is to community safety first, to fair and just retribution, and to the orderly management and operations of our prison systems. They are the professionals, and we ask that they have the authority after a decade and a half to do what is their job as to all inmates in the Department of Corrections, all of them, including the one who stands before you today. Thank you.
Mr. James?
I have a statement, Your Honor. We have one witness.
Assuming the defense has witnesses, at this time I'm just asking for an opening statement and then we'll go through witnesses.
Thank you, Your Honor. It's been a long week. And I can imagine that long week with Lance Crossman wondering where his daughter was. Andy McCauley knew exactly what he had done to her, knew exactly where her body was. Her mother and her father spent that time agonizing, holding out hope and prayer that maybe Riley would walk back into that door. That maybe they would see their daughter again. That this time of year, she would be a senior at Berkeley Springs High School. She would be getting ready to move on to the next phase of her life. They'll never have that opportunity. They will never see their daughter again. This isn't about a parole board looking at Mr. McCauley 15 years down the road. When you think of mercy, what mercy did Andy McCauley show to Riley Crossman? When he came back and he disposed of her like a piece of trash. There's no grounds for mercy in this case. Absolutely none. And we ask that you take that responsibility. Not a parole board. You, the jurors that sat here and saw this evidence. And I ask that you deny any mercy in this case, as Andy McCauley denied mercy to Riley Crossman.
Mr. Arnold, do you wish to call any witnesses?
No, Your Honor.
Mr. James?
State calls Lance Crossman.
Sir, do you solemnly swear or affirm that the evidence you present in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Sir, if you want to, sometimes it's easier just to use the witness stand. It's easier for our court reporter, I should say. And you may remove your mask. Thank you, sir.
Thank you, Your Honor. Thank you, Dan. Members of the jury, thank you for hearing me. How do you summarize your child's life? How do I explain what she meant to us? I can't. Riley was the type of child you hope to have one day. She was kind and gentle and loving and full of life. Riley will be forever frozen in time, only living on in our memories now. And she will forever be 15 years old to us. Counsel mentioned 15 years. In 15 years, he may be eligible for parole. She only got 15 years. That's all she had. 15. So if this is a case of mercy, like Mr. James said, where was the mercy in this crime? Where was it? Where was the mercy when he walked into her room where she's supposed to feel safe? Where's the mercy when he attacked her? Where's the mercy when he put her in a trash bag and dumped her off the side of the road like garbage? Mercy was nowhere to be found in this crime, and I would ask that no mercy is given in this sentence. Thank you.
I'm assuming there's no other witnesses, Mr. James?
None from the state, Your Honor.
Any closing arguments to be made, Mr. James?
No, Your Honor.
Mr. Arnold? Actually, do you want me to instruct them before you do your closing argument?
Yes, sir.
Members of the jury, we are entering the last phase of the trial. After closing arguments of the parties, you will again be asked to retire to the jury room to deliberate. You have found the defendant, Andrew J. McCauley, guilty of murder of the first degree. This conviction requires a sentence of life in the penitentiary. Your role is to determine if the court should add a recommendation of mercy to the life sentence. The law does not place a burden of proof on either the state or the defendant for the mercy phase of a murder of the first degree trial. You, the jury, must determine the issue of mercy in this case exclusively from the evidence, that is, from the testimony of the witnesses and exhibits. Again, you must disregard completely testimony to which an objection was sustained or exhibits ordered stricken out of the record. You must not forget the prior instructions given regarding witnesses' testimony and evidence. Those instructions will be provided to you again to take to the jury room. A recommendation of mercy would mean that the defendant, Andrew J. McCauley, could be eligible for parole consideration after having served a minimum of 15 years. The court further instructs the members of the jury that mere eligibility for parole in no way guarantees immediate parole after 15 years, and that parole is given to inmates only after a thorough consideration of their records by the parole board. The law requires that a jury verdict recommending mercy or no mercy be unanimous. The jury room is no place for unreasonable pride of opinion or stubbornness. It is the duty of every juror to consider all the evidence in the case, the instructions of the court, the arguments of counsel, and to discuss the evidence with the other jurors with an open mind, considering the views of fellow jurors, and if it can be done without sacrificing conscientious conviction, agree upon a verdict. Mr. James, there's no further closing arguments, so Mr. Arnold.
Ladies and gentlemen, in light of the emotion of this case, and in light of what you've just sat through for a week, and with respect to the verdict that you've just rendered, the easy path here clearly is to follow our reactionary path, which is murder, no mercy. But in West Virginia, our law requires more from you. It asks that this question of mercy be considered by you through deliberation. Deliberation separate and apart from the deliberation on the offense of conviction. We ask you to be a distinct and separate body from the one that returned the conviction, to deliberate only on the question of mercy. This vote, this decision is not, I want you to understand, this is not about the defendant exclusively. This is about, it's a vote on us. It's a vote on what we wish to say to each other. I'll remind you that the first and foremost concern of a parole board is community safety. That's written into its mission statement. If the parole board determines that there's an issue with community safety, that will end the inquiry. If, however, that concern is satisfied and addressed, then they will weigh other considerations, including victim impact, including prosecutorial input. We do follow a retributional model of justice in this country. So retribution, while not the only concern, is a driving one. And the parole board will look at the facts of an underlying case before making a decision. They're required to. We do not ask that you grant this defendant parole in the future. And if he has no extraordinary story to tell, then my guess he will never be paroled. What we ask respectfully is that you leave open the possibility, however remote, that something extraordinary could happen. Atonement, reconciliation, redemption. They're not empty words. And we ask that as a community, we not simply hear these words passively from time to time, but we ask that you put them into practice. That's the hard thing to do, not just listen passively. Judgment has happened, prison is happening, a life sentence is happening. But what you have now right in your hands is unique. Likely to never happen to you again. You have the ability right now and the power to determine, to define what justice means for us. A justice with a single thread of mercy woven through it, or without. You can communicate that we are our more perfect selves, that we are better than simple stimulus response reactions. You can communicate our belief in atonement and redemption. Your single word mercy does not communicate that those ideas will manifest, merely that they might. And maybe these words will not mean anything to a particular defendant, but they should mean something to us. Because today you get to define justice in our community by whether or not to attach this very important word. If you do, you can do so with the assurance that the community safety will not be compromised, and you can do so with the assurance that the parole board will weigh in everything. You can decide to agree with this message. We attach mercy to this verdict not because you deserve it, but because of who we are and how we define ourselves. We do not forgive you, nor will we. That's too big an ask. We believe, however, in atonement and redemption. And when you are before a parole board a long time from now, if you do not have an extraordinary story to tell by your words and your life, the parole board will do as it will. But we, by our belief in justice, want to put that squarely in your court and keep that word as a part of the fabric of our system. And in this, we define ourselves, not just any particular defendant. So thank you for giving this careful deliberation and attention and reflection. And please consider attaching this one word to the verdict. Thank you.
All right, ladies and gentlemen of the jury, we will again, I think you already have the evidence back there. You have, you have the old instructions. We'll have the new mercy phase instruction and a verdict form that we will send back with you momentarily.
All right.
Zach, you want to go get the verdict form?
Andy McCauley Jr., 43 years old, found guilty on all charges. Took the jury about 4 hours to come to that conclusion over 2 days of deliberation. Let's go back in.
Zach is going to go get the verdict form for counsel to review prior to delivering it to the jury. Madam Clerk, you want the instructions? Should I ask any objections to the instructions that I read? I'm assuming not, otherwise I would have heard them.
No objection from the state.
While he's taking care of getting that verdict form, I did indicate I would put on the record there was an incident when the defendant arrived this morning. He was in the clothing that he appears in court, although he was handcuffed and shackled, I believe, at the time when he was riding up the elevator, that the doors to the elevator opened on both sides, and so 2 jurors did see him. He was not wearing an orange jumpsuit or any prison attire. He simply had on the handcuffs, so I did want to put that on the record. We're just waiting on the verdict form. Just hold up and wait for that verdict form. I want counsel to look at it before it goes back.
All right, as you heard, they're just waiting on the verdict form so that it can be taken back to the jury. And this is the verdict form for the mercy phase. The jury has already come to their verdict in the guilt phase, obviously. 3 counts, all 3 guilty. The defendant didn't show any emotion despite the amount of emotion in this courtroom today. We did see him break down earlier during the trial, but not so much today during what would, I think anybody argue, is the most emotional part of the trial so far during
Got the right
the
case number on
mercy
the top,
hearing.
Zach?
Well, let's listen to the judge.
Any objection as to its form, Mr. Arnold?
No, Your Honor.
All right, then. Go ahead and give that to our bailiff and can send that back with the instructions. Anything else we need to take up prior to standing in recess?
Nothing further from the state.
All right, we're in recess.
All right, the jury now deliberating the mercy phase, the penalty phase, if you will, in West Virginia. Jurors, if you are found guilty of first-degree murder, it's life without parole unless the jury that convicted you attaches mercy to the verdict. That's what this jury now has to decide.